Bonjour, mes enfants. C'est votre uncle. Oui, it's Uncle Dan, the lawyer man, not Uncle Dan, the violent man, as I usually am. I'm going to put this on a new channel. I'm here tonight to talk a little bit about the Karen Reed case, which has been a gold mine for YouTube and possibly other content creators. I mess around with YouTube, not other platforms. I'm responding tonight to a video by JD, a lawyer explains, and I'll link to it. Bringing in third parties can force a lot of people who don't want to testify. And I'm not going to do a reaction video to it. Forgive me for that, but I did want to talk about it. And I want to talk about how JD, I forget his name, Mr. DeWitt or Mr. Witt, Missouri, a retired Missouri appellate attorney. I'm an old Missourian. I'm a lawyer. I'm not retired. I've done a lot of appellate work. Not in Missouri, not in Massachusetts, but I've done a lot of federal law. Anyway, JD, a lawyer, explains, says that Karen Reed could bring in third parties in the civil suit, not new civil suit, but in the civil suit asserted against her by the O'Keefe family. The civil suit brings in three defendants, names three defendants: C.F. McCarthy's, Waterfall, and Karen Reed. And C.F. McCarthy's and Waterfall are restaurants which allegedly overserved, as the language goes, overserved Karen Reed. And the family is seeking to recover from Karen Reed for getting drunk, and their theory, which is the state's theory, she got drunk, she backed into John O'Keefe, whether deliberately or negligently. It wouldn't have to be deliberately for the family's case, but anyway, that she got drunk, backed into him, and they want to sue the restaurants, the taverns, for over-serving her. That is, for letting her get drunk. And she apparently was drunk during that morning when he was killed. And I'm not going to get into questions of her guilt. I didn't watch the trial closely enough. Anyway, Mr. J.D., a lawyer, explains, suggests that she could bring in, that is, in this case, she could bring in as third-party practice a variety of people, and she identifies Brian Albert, Chris Albert, Jennifer McCabe, Brian Higgins, and Kelly Dever. Or, I thought it was Dever, but I don't know, Dever, I guess. Kelly Dever. And part of it, he says, well, maybe somebody else killed John O'Keefe. And he also has theories about the slip-shot investigation, and even he calls it a conspiracy of silence. But he's suggesting that she could name these parties as what are called third-party defendants. The first part of his video correctly explains third-party practice in Massachusetts. Massachusetts follows the Federal Rule of Civil Procedure 14, which is third-party practice. And under both Massachusetts, now I'm not a Massachusetts lawyer, but I read up on it, and this is the case. I'm not your lawyer though. But under that rule, you can file a third-party action where you bring in, is what's called a third-party defendant. You can bring in a defendant if you say, yeah, I caused plaintiff's injury, whatever it may be, but I did that because of so-and-so. For example, let's say Karen Reed is sued because she's drunk, and plaintiffs the O'Keefe family hadn't brought in the two bars. She could have brought a third-party action against them and said, yeah, I was drunk and I caused John O'Keefe's death, but I was drunk because these parties breached an obligation in tort. In this case, you can have other theories, but they've not breached an obligation, violated or breached a duty that they held to her, breached a duty of care that they held to her. It'd be a negligence claim against them too, that they had a duty of care toward her, that they breached that duty of care, and that it was proximately cause of the damages at issue, which actually the damage was to John O'Keefe. So that would be true third-party practice. But what J.D., a lawyer, explains is saying instead is that she could bring a claim against other people for having killed John O'Keefe, not her having killed him, not her having had anything to do with it. Her defense, I believe, would be, I was nowhere near the place when he died. And so it isn't derivative liability. Massachusetts rule, Civil Procedure Rule 14, like the federal rule of Civil Procedure 14, requires that it be, that the third-party defendant's liability be derivative of plaintiff's liability. That there's a, I like to think of it instead as flow-through liability. If I'm liable, you're liable, and it flows through me. You don't say, so if they say, okay, if it was me, then it was them. Not, it wasn't me. Must have been some other party. No, child, it wasn't me. You just say, if it's that, you just say, it wasn't me. We'll go over there and look at them. So let me read a couple of things from that I found in it. From the reporter's note to Massachusetts Civil Procedure Rule 14, it should be noted that Rule 14, like Federal Rule 14, does not, and skip a little bit, does not permit the defendant to tender an additional defendant to the plaintiff. That is, you don't get to say, hey, it wasn't me, go after this other party. If the plaintiff has not chosen to sue the third prospective third-party defendant, the original defendant, in this case Karen Reed, may bring in the third-party defendant only if the third-party defendant is or may be liable to the original defendant. So this rule requires the defendant to demonstrate derivative liability. Here's a case out of the Ninth Circuit from 1988. Stewart v. American International Oil and Gas Company, 845 F. 2nd, 196 from 1988, Ninth Circuit again. Quote, a third-party claim may be asserted only when the third party's liability is in some ways dependent on the outcome of the main claim and is secondary or derivative thereto. So you got to say the third party's liability is secondary to or derives from the outcome of the plaintiff against the defendant. And it does not seem to me that Karen Reed is asserting that at all. She is asserting that these claims, it's just somebody else did it. Somebody else did it. Not, I did it, and it flows through me, or it's derivative. This liability is derivative of the third party, of the original claim. Wright and Miller, Wright and Miller, 6 Federal Practice. Wright and Miller on Federal Practice and Procedure is, one of the standard treatises on federal practice. And again, Massachusetts mirrors federal practice in this regard. The claim cannot simply be an independent or related claim, but must be based upon plaintiff's claim against defendant. Again, it's not it wasn't me, it was somebody else. If it was me, it's because of them. So it's got to be a derivative or flow through. The crucial characteristic of the Rule 14 claim is that defendant is attempting to